Good morning. Thank you so much for joining us for today's Wednesday webinar, Social Security Disability for Neuropathy. Before we go any further, I do want to briefly mention the same thing that I say at the beginning of all of our webinars, which is that today's webinar is not intended to be legal advice, but is instead meant to serve as additional background information for those who have questions about applying for disability or thinking about applying for disability, and today specifically disability for neuropathy. The other thing that I want to mention is we don't take any questions on the live webinar, and we are very limited in what we can respond to in the comments on the replay. So if you're watching on the live, we'll go ahead and drop a link in the chat now where you can go ahead and schedule a call at a time convenient for you where we can get on the phone and answer the questions that you have. Similarly, if you're watching on the replay, that link will be down below. So again, we don't answer questions on the live or really in the comments on the replay. And the reason is not because we don't want to help, but it's because we typically need more information. And I don't want you to put any of your personal identifying information or your health information out there for others to see and hear. But I am happy to have a conversation with you one-on-one to see if there is something that I can provide any type of guidance or information on. So with that being said, let's go ahead and get started. Here's our roadmap for today. We're going to, if you've watched any of our webinars before, they all tend to have the same path. We'll start out by talking about Social Security disability basics, some guidance from the agency. We'll talk about a potential listing that might be connected with neuropathy. We'll talk about some considerations to make. And then finally, we close out with some of the ways an attorney may be able to help you with your disability claim. A little bit about me. My name is Caitlin Wildonor. I am the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law. We help clients with their Social Security disability claims from the initial application stage through the hearing and appeals counsel levels. We are based in Florida. We do help clients outside of the state as Social Security is a federal practice area. So if you do have questions, please do feel free to reach out. Again, it is a federal practice area, so it is something that we can typically speak to clients in other states about if you do have questions. Here are the Social Security disability basics. There's two different Social Security disability programs. They're both going to require that you be disabled for a period of at least 12 months, which means that you are completely unable to work due to physical and or mental impairments for a period of at least 12 months. So that means that Social Security, they're not going to pay any temporary benefits. If you're out of work for 6 months due to a condition, then that may very well be a disabling condition, but for Social Security purposes, because that disabling condition did not last at least a year, you likely will not be found to be disabled. Now, that does not mean that you have to be disabled a whole year before you apply. And in fact, I generally recommend you apply as soon as you think you will be disabled and unable to work for at least a year, for a couple reasons. Number one, it's a long process. And number two, oftentimes when you apply can dictate how great your back due benefits can be. So for example, for SSI benefits, Social Security cannot pay prior to the date of the application. So you want to get that application in sooner rather than later. For SSDI benefits, Social Security can pay retroactive before you apply, but they can only pay retroactive about 12 months, okay? So that's why I always recommend apply sooner rather than later. Sometimes what will happen is the agency will look and they'll say, look, it's too soon. We can't decide whether you're still going to be disabled in a year. And so they kind of let you know that and they hold on to it. Sometimes they think you're not going to be disabled for a whole year and they'll deny it. There is an appeals process, of course, for that. And please, if you do remain disabled after receiving that denial, remaining disabled and unable to work, absolutely get that appeal filed. Okay, so that's the similarities. They're both going to require that you're disabled and unable to work for a period of at least 12 months. Where they differ is SSDI, Social Security Disability Insurance, is going to require that you have a certain work history. Generally speaking, we say that you must work 5 of the last 10 years. Okay, they focus on your quarters of coverage and your work credits that you have earned from working and paying into the Social Security system. SSI does not have a work history requirement, but instead has income and asset restrictions. So there are income restrictions, and then those vary depending on household size. So that's why I don't get into those on these webinars. Asset restrictions are much easier. You cannot have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married. Okay. Does not include one home and one car. It does include, if you're married and you have two cars, it's going to include that second car. It's also going to include any property that you may own. It's going to include any bank accounts, investment accounts, retirement accounts. Anything like that is going to count towards the assets. And again, those are capped at $2,000 if you're single and $3,000 if you are married. Excuse me. Okay. When you submit your application for Social Security disability benefits, the very first thing they're going to look at is which of the two prongs, either SSDI or SSI, might you meet? Do you have enough quarters of coverage for SSDI benefits if that's what you've applied for? Do you have too many assets or too much income to qualify for SSI? So that's the very first thing they're going to look at, is to make sure that whichever program you applied for, you meet that second prong. As long as you meet that second prong, so with SSDI, as long as you have sufficient number of work credits, and with SSI, as long as your income and assets are below their thresholds, they'll move to this 5-step evaluation process. They're going to look, number one, are you currently engaging in substantial gainful activity? That means, are you working 20 hours a week or more, or are you earning more than $1,470 a month in gross earnings? Okay, so that's gross. So it's before taxes, before health insurance, before anything gets taken out. If you are working more than 20 hours a week or earning more than $1,470 a month, Social Security is going to deny the claim at step 1, and they're going to say you cannot be found disabled under our rules because you're engaging in substantial gainful activity. Okay. If you are not engaging in substantial gainful activity, they'll move to step 2, where they look at your medical records to see, do you have at least one severe medically determinable impairment? If you do not have at least one severe medically determinable impairment, the analysis stops there and you'll get a denial. If you have at least one severe medically determinable impairment, they'll go to step 3, where they look at the listings. Again, we'll talk about one of the listings in just a moment. They'll look to see through the medical records, do you meet or equal one or more listings included in the Blue Book of Listings? If you do, the analysis stops there and you'll receive that favorable decision saying that you are found disabled under our rules. Sometimes they'll tell you which listing you meet, sometimes they don't. It depends on where you are, where you get approved in the disability process. If you do not meet or equal a listing, excuse me, they will go to step 4. They will look at the medical records. Knew there was another one coming. They will look at the medical records to see what is your residual functional capacity, which is what do they believe you are capable of doing despite your conditions and limitations. Using that RFC, they will look at your past relevant work and they will say, okay, can an individual with this RFC go back and perform this past relevant work? If you can, go back to your past relevant work based on the RFC that the agency has assigned, then you will receive an unfavorable decision. You'll receive a denial. If you cannot go back to your past relevant work, then the agency still keeps that same RFC and they go to step 5, where they see, okay, you can't go back to your past work, but is there any other job that exists in the national economy, considering this RFC, your age, education, and any transferable skills you may have from your past work? Are there any other jobs that exist in the national economy that you may be able to do? If you cannot go back to your past work and there is no other work that you can adjust to, then you will receive a favorable decision. If you cannot go back to your past work, but there are other jobs that you can adjust to, then you will typically receive an unfavorable decision or a denial. Okay, so that's the 5-step process. That's how the agency looks at and evaluates disability claims. Steps 3, 4, and 5 can be very, very tricky. And that's where an attorney can really come in and help try to add value is at those steps to either make the argument that you meet or equal a listing, or that you cannot engage in your past work or any other work based on your RFC. So adults can qualify for Social Security disability benefits if their residual functional capacity is less than what their past relevant work would require, and or it prohibits them from engaging in any type of substantial gainful activity on a regular and ongoing basis. Okay, that can sometimes mean that they are unable to sustain competitive employment. And sometimes if you're in a hearing, you may hear a vocational witness respond based on a certain hypothetical that that individual would be unable to sustain competitive employment. Okay. The other thing that I do want to mention is adults over age 50 may qualify for benefits using the grid rules. If that is you, if you are over age 50, I know we do videos on them regularly, and I believe we've done webinars on the grid rules. It seems very black and white, but I can promise you it is not that black and white, because it does still include your RFC. So it still heavily relies on the medical records and what they are saying. So it's not something that is blatantly obvious that you are, 56, you'll be approved through the grid rules. They can certainly be there as a helper and as another tool in the toolbox for trying to get a favorable disability claim. Again, SSI benefits are only payable to children and adults with limited resources and income and assets. That's resources. SSDI benefits, on the other hand, are payable to adults who have earned a sufficient number of credits through their work and to children whose parents are deceased, retired, or disabled. So children can receive SSDI benefits if their parent, if they have at least one parent who is either deceased, retired, or disabled and currently earning Social Security benefits on their own record. Okay, so there are separate rules for that as well, but that can sometimes be an option. Here's the listing that we can talk about with respect to neuropathy. Listing 11.14, peripheral neuropathy, is going to require that an individual have medical evidence of disorganization of motor function in two extremities that results in an extreme limitation in that individual's ability to stand up from a seated position, balance while walking or standing, or use their upper extremities. Alternatively, you can meet listing 11.14 if there is medical evidence of a marked limitation in physical functioning, as well as one of the following areas of mental functioning: understanding, remembering, or applying information, interacting with others, concentrating, persisting, or maintaining pace, or adapting or managing oneself. So as you can see, there are those two ways to possibly meet the listing for peripheral neuropathy. Now, this is just one listing, especially if you have other conditions that are impacting your ability to work. There very well may be other listings that you may want to look at and consider. Remember, when Social Security is reviewing your file, they are looking at the medical records. So what I always recommend to clients and potential clients is most, if not all, especially providers for physical medicine, not necessarily for mental health, but physical medicine, most, if not all, providers by now have a patient portal that you can log into and you can actually see your medical records. And so that can be really helpful, because sometimes you'll have a doctor who will say one thing to you and then another thing will be in the chart and you have no way of knowing until it's too late. But if you go in to your chart and your notes and your portal, you can kind of keep up with it. And you can even ask them at the next visit, "Doctor, I know, I think at the last visit you told me this, but I noticed in my chart that you wrote this down. I just want to make sure we're on the same page, and that, my chart is properly notated and that I know what I'm supposed to be doing in hopes of getting better." So that it can really be helpful to have access to that patient portal so that you and your doctors, you're sure you're on the same page. And again, like I said, it can help you to know, what is Social Security going to see? And some doctors say something and they speak erroneously. And sometimes it gets input into the chart incorrectly. And so it can oftentimes just be an error. So it doesn't hurt to make mention of that, to say, oh, last time we talked, it said this, but then when I looked at the chart, it said that. Is there a way we can get that chart corrected? Or did I misunderstand what we talked about and the chart is correct? So that can be a really helpful tool to have access to as well. As I was just talking about, medical records are paramount. They are so important because that is what Social Security uses to base their decision off of. Not that what you have to say isn't important, because it is, but what they like to see is they like to see the medical records and then your testimony or your responses to the forms that they send out matching up with that. So that way the medical records and your words match up with each other, and they both point to a finding of you are disabled and unable to work. So medical records are very, very important because Social Security also views them as unbiased, whereas your testimony and responses are going to be biased towards trying to get the disability that you've applied for. So that's the other factor in why medical records tend to be so important. Remember, the issue in disability cases, if you don't meet a listing, is not just can you go back to your past work, but is there any job that exists in the national economy that you are going to be able to perform? Okay. To that end, functional capacity can also be relevant. If you don't meet the listing, then that's exactly what's going to come next, is Social Security is going to look at what your functional capacity is for performing activities of daily living, and they're going to use that to determine, can you go back to your past work or any other work? All right, here's a list of some of the ways an attorney can help you. This is not an exhaustive list. It's some of the things that come up most often, though. So what we do is we provide guidance on what correspondence from Social Security actually means, including whether or not you need to take action on it. We file necessary appeals, either if you are already a current client of ours, or if you reach out to us within a sufficient time that we can file that appeal. We review your medical records and case file. We discuss what additional records might be helpful for your case. We do review your documents for accuracy and completeness and discuss what Social Security is looking for in their requested forms. We also work with you to provide updates to and from Social Security throughout your claim. And if you get to the hearing stage, we prepare you for that hearing before an administrative law judge, and we would also question you and any witnesses during that hearing. If you've watched any of our webinars before, or even some of our other videos, you know that we don't typically, when I say witnesses, I don't typically mean your family and friends. We try to get that witness testimony in other ways. The witnesses that we are there to typically question might include a medical witness or a vocational witness asked to be there by the Social Security Administration. All right, here's our contact information. Please do feel free to give us a call, send us an email. We'll go ahead and drop the link for scheduling a call in the chat again. If you have any questions, please do feel free to reach out to us. We are always happy to help in any way that we can. And if for some reason we cannot help, we do try to point you in the right direction of somebody who can. So thank you so much for joining us today. Have a wonderful day.